Welcome and thank you for joining Part 4 of Seyfarth's micro-webinar series, Recent Legislative Developments Affecting DC Employers. This installment of the series will focus on hiring and onboarding. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Carla Grossenbacher. Carla, you may begin.
Thank you. Hello, everyone. I'm Carla Grossenbacher, and I'm the chair of the Labor and Employment Practice in the DC office of Seyfarth Shaw. And welcome to our most recent installment on legislative developments in the DMV, this one covering hiring and onboarding. Your presenters today are Ray Baldwin and Eric Jansen, both our longtime rock star labor and employment partners in the Washington, D.C. office. Both are employment litigators with long track records of success and are trusted counselors on employment matters to their clients. In terms of specialties, Ray is our jury trial specialist. If there's a case going to trial in DC, you can bet that Ray is either handling it or he's behind the scenes offering his advice and expertise to his colleagues. Eric has developed an expertise in the application of cannabis laws in the workplace. And whenever those issues arise, Eric is everyone's first call. Eric also has a special focus in representing hospitality clients. So you're in for a treat today, and with that, I'm going to turn it over to Ray and Eric.
Thanks, Carla. Very kind of you. And thanks, everybody, for taking a few minutes to chat with us today about what's going on in the District of Columbia. First thing we'd like to talk about today is the DC Non-Compete Clarification Amendment Act. I think, as everyone knows, the trend with respect to non-competition agreements across the country is decidedly against them. In fact, the Biden administration has even proposed that they be outright banned. The district has been a part of that trend. Back in 2020, pre-pandemic, seems like another life now, doesn't it? The DC Council passed one of the most restrictive non-compete bans in the country. It would have even prohibited employers from telling their employees that they couldn't work for a competitor at the same time they were working for them. Well, as you might expect, there was a significant hue and cry from the business community, which caused the DC Council to kick the can down the road for months and months and months on the effective date. And the end result was the Non-Compete Clarification Amendment Act of 2022. Next slide, please. Let's go one more. And we could go one more. There we are. So this law, go back one, please. There we are. So this law became effective on October 1, 2022. The key point is that for most employees in the District of Columbia, non-competition agreements remain banned. Anybody who earns less than $150,000 cannot sign or agree to a non-competition agreement. Of course, because we're dealing with the law, there are some exceptions. One is for highly compensated employees who make 150 grand or more a year, 250 grand if you're a doctor or medical specialist. This carve out is in line with a number of other jurisdictions, Colorado, Washington State, amongst them. These folks can sign a non-compete, but it can't exceed a 1-year restrictive period. In other words, you can't say, hey, you can't go work for Acme Company for 2 years after separation of employment, only one. And you have to give highly compensated folks 14 days notice within which they get to decide whether to sign the agreement or not. There's another exception if it's in the sale of a business. That's got to be a part of the business transaction agreements, or be executed contemporaneously with that transaction. The idea being, of course, that it would be fundamentally unfair for a buyer to be able to turn around and compete the other way around, for the seller to turn around and compete against the buyer post-transaction. Importantly, this law is not retroactive. It does not invalidate existing non-compete agreements. That said, it will be interesting to see when cases start to be adjudicated whether courts will take into account, as a matter of public policy, the District of Columbia's expressed desire to limit the enforcement of these agreements. And by the way, just before we came on, I looked, and as of today anyway, according to Westlaw, there are no reported cases dealing with this new law. Unlike its predecessor, this new agreement, new amendment, allows anti-moonlighting provisions. So it's still okay to say to your folks, hey, you can't work for a competitor or another employer while you're working for us at the same time. But you have to give folks 30 days notice of these policies. So if you hire somebody today, in 30 days, you got to give them that conflict of interest or anti-moonlighting policy, and you must reasonably believe that the work that they want to do could lead to disclosure of business information that you don't want disclosed. This law leaves, it is silent with respect to non-solicitation of customers and employees, and those provisions are presumably still permissible, although they should be scrutinized to ensure that they don't unintentionally create a non-compete situation. Next slide, please. So what's a non-compete? Well, it's a pretty broad definition. It's really anything that prohibits somebody from working for another for money or operating your own business. An employer is anybody who employs anyone else in the District of Columbia. Unlike some laws, there's no minimum number of employee requirement to be considered an employer. If a person spends more than 50% of their time working in the district, or regularly spends a substantial amount of their time working in the district, but not more than 50% in some other jurisdiction, they are an employee for purposes of this law. And with respect to prospective employees, the same definitions apply, except that the employer must reasonably anticipate that they're either going to spend 50% or more of their time in DC, or a lot of time, but not 50% of their time elsewhere. Highly compensated is $150,000 or more in a consecutive 12-month period. This includes all compensation, salary, bonus, overtime, stock, whatever. Everything is included to get to that $150,000 threshold. $250,000 with respect to medical specialists and physicians. Next slide, please. So what happens if you run afoul of this statute? Well, your agreement may be invalidated, for one. You could be subject to a fine anywhere from $350 to $1,000, and if you're a repeat violator, could be up to $3,000. Employees also have the right to go to the mayor or take you to court with respect to the offending agreement. So while these penalties may not be onerous in and of themselves, the prospect of litigation, which, as we all know, is time-consuming, expensive, and generally unpleasant, it is a sound practice not to violate this statute. Next slide, please. So if you do have a highly compensated employee and you want to get them to sign a non-compete, you have to make sure that non-compete is narrowly tailored so that it doesn't extend beyond what you actually need to protect your business interest. So we see a lot of non-competes agreement non-compete agreements out there that say, hey, look, you can't do anything for anybody who competes with us. Well, that's not going to work under this law. Narrow is better. You have to narrowly define it to specific roles, services, or in a perfect world, competing entities. Make sure the geographic limitations are reasonably tailored, and importantly, it can't extend beyond 1 year. Lots of folks out there have 2, even 3-year non-competes now. Those are now forbidden. You got to give 14 days notice, as we said, and when you hand them the non-compete, you have to include the language below. And the idea of this language is to ensure that the employee knows that non-competes are prohibited for many employees, and that there are certain conditions to their enactment. Next slide, please. Okay, so what do we do here? Well, I'm suggesting that folks take a look at who may or may not be covered in their organization, figure out whether those folks have agreements and whether you want them to have agreements. Take a look at your policies and make sure they don't create an unintentional non-compete situation that might run afoul of this law, even though it's not a technical non-compete. If you have anti-moonlighting or conflict of interest policies, make sure you're giving people 30 days notice. Hand them the policy and give them the 30 days notice. I wouldn't go back and amend your agreements. I get that asked that fairly often. The reason I wouldn't do that is because as soon as you amend the agreement, you've created a new agreement, and this law is going to be applicable. Better to keep the agreements in place that you have than to try and amend. And obviously give notification if you're going to ask somebody. And then finally, keep your eyes and ears open for changes to the definition of highly compensated employee. What's supposed to happen on January 1, 2024, and each year thereafter is a new threshold is supposed to be published in line with the consumer price index. Presumably the threshold will continue to increase, but we should know here in a few months. I'm going to turn it over to Eric, who is our unofficial drug czar.
I prefer weed lawyer, but that's fine. Thank you, Ray. I appreciate it. So perhaps one of the biggest legislative developments for hiring managers in DC this year has involved these new employment protections for applicants and employees who are using cannabis either for medical reasons or recreationally, more commonly referred to as kind of adult use, cannabis use. So that, that took shape, through the DC Cannabis Employment Protections Amendment Act. But before we get into that, a little bit of background. As many of you already know, back in 2015, the DC government passed the Prohibition of Pre-Employment Marijuana Testing Act. And this act, prohibited pre-employment drug testing for cannabis until at least after a conditional offer was extended. So the catch with this law was that the existing law, that nothing prohibited that employer from post-offer drug testing, including taking any type of adverse employment action against a newly hired employee for violations of, say, their drug-free workplace policies, regardless of whether it was medical, whether it was off-duty, whether or not there was any demonstrated impairment at work. At least under this law, the employer could essentially hire the employee, ask for a drug test, whether random or otherwise, and turn around and fire that employee if there was a zero tolerance policy for any type of positive drug test. So kind of pro-cannabis, other employee rights groups really kind of pushed hard, um, to get the DC Council to pass additional employment protections for individuals like there are in many states currently throughout the country in a variety of forms and fashions. Next slide. All right. So, this past year, the DC Council, in response to that, enacted the Cannabis Employment Protections Amendment Act, or CEPA. This law prohibits DC employers from taking any type of adverse employment action against applicants as well as employees based on either use of cannabis, their status as a cannabis program patient or cannabis card holder under the medical marijuana program, as well as taking adverse action against anybody who had the presence of cannabis in their system that was found through an employer requested or required drug test without additional factors indicating impairment. So it wasn't even enough that you had a positive test. You have to demonstrate additional factors indicating impairment, which we'll talk about in a second. So under this new law, essentially employers are prohibited from taking any type of adverse employment action against their employees or even applicants regarding cannabis use off premises during non-work hours, again, unless they can demonstrate there is an impairment at work. So regarding this kind of third category of impairment, the statute says that the employee must manifest specific articulable symptoms while working that could substantially decrease or lessen their performance of duties at work or tasks for their specific positions. Unfortunately, there is no further guidance at this time what specific articulable symptoms are, but I think it's safe to say at this point that employers should treat this similar to reasonable suspicion of, say, alcohol, where they are looking for, as objective or indicia as possible, whether it's glassy eyes, instability on their feet, or, sleepiness, like falling asleep at work, obviously, speech issues, slurring of speech, things like that you would look for in an issue of alcohol intoxication would be things that an employer who wants to take adverse action based on an individual's positive drug test, really needs to be able to look for and articulate if they want to, stay on the right side of this particular law. There very well could be further guidance coming. I would note that originally this was supposed to be enacted in July. Unfortunately, it was tied to budget approval for the DC Office of Human Rights, who's been put in charge of enforcing this new law. The DC Office of Human Rights was recently, I think it was last week, approved for funding. And so that budget will take place, and it is anticipated that this law will be fully enforceable as of the new fiscal year, so on October 1st of this year. So it's definitely something to be mindful of. We anticipate there being additional guidance. We'll talk about it in a moment. Some additional notice requirements or templates we're going to see from the DC Office of Human Rights. Let's go to the next slide. All right, so we talked about what we can't do. Let's talk about what you can do as employers. So perhaps most importantly, and this is in DC and other states, employers are never required to tolerate any impairment at work. They can still engage in post-accident testing, reasonable suspicion drug testing at work. Also, under this law, you're not required to permit or accommodate either the use, consumption, growing, sale, transfer of cannabis at work, and that includes whether it's medical or adult use as well. Also under the statute, there were further carve-outs, said that there was an exception for employers who take adverse action related to the use of cannabis if they are required by federal statute, federal regulations, or a federal contract or funding agreement, to prohibit this sort of thing. So if you're a federal contractor and your contract says zero tolerance for failed drug tests for cannabis, employee test positive, regardless if there's any impairment or if it's off-duty use, in that particular situation, you will, as the employer, have some protection under this law and would be permitted to take, an adverse employment action against that individual. Likewise, under SEPA, there are also exclusions for those working in safety-sensitive positions, which we'll talk about in a second, and as best, what guidance the DC government has provided on that. Next slide, please. In terms of penalties under SEPA, individuals who believe an employer has violated the law can either file a complaint with the DC Office of Human Rights, or they can file a private individual lawsuit. Right now, there is no indication one way or the other whether there's any sort of mandatory exhaustion requirement through DC Office of Human Rights, like there is for discrimination claims, through the EOC and the like. In terms of the penalties, there are civil penalties, half of which are awarded to the complainant, similar to DC's background check law, where they get, kind of turned into a little cottage industry on that particular law, where people are looking for violations just to get the half of the penalty. The lost wages, reasonable attorney's fees, and under the private right of action, they can obtain compensatory damages as well, which would be, for instance, pain and suffering, if there's any sort of demonstrated evidence of that, as well as equitable relief, and which could include reinstatement under this law. So next slide. So what should you do? So in terms, I guess, of next step, obviously we're waiting for further word from DCOHR on any further guidance. But most importantly, we're waiting on the sample template. So there is, first and foremost, a notice requirement. First, that employers must provide upon hire and to existing employees on an annual basis a notice alerting them to their protection under this law. In addition, there's an additional notice requirement where employers are required to inform any employee if they are working in a designated safety sensitive position and therefore not subject to the protections under SEPA. So with regard to safety sensitive positions, the statute says these are those that are reasonably foreseeable that if an employee performs in that role under the influence of drugs, they could cause actual, immediate, serious bodily injury or loss of life to themselves or to others. So it's a bit broad and could very well, capture a fair amount of positions. The Act does, to their credit, provide a list of kind of non-exhaustive examples of safety-sensitive positions for which SEPA does not apply. That would include security services, those operating motor vehicles or heavy and dangerous machinery, those working on an active construction site, working with gas or utility lines or hazardous material, those who whose duties involve supervision or of those who reside in a institutional or custodial environment. So think prison workers, boarding schools, mental health, rehab facilities, as well as those who are involved in the administration of medication or perform supervised surgeries or other medical treatment involving professional credentials. So again, this would cover most healthcare workers, doctors, nurses, and the like. So again, we're waiting to get further guidance, but it'd be wise for employers to start revising policies and practices so they don't run afoul of this new law come October with new hires and obviously provide the requisite notice. Next slide. So now that we talked about the recent laws involving hiring, onboarding that are already on the books, I'm going to turn it over to Ray for a second to talk about some things that are coming down the road for decent employers.
Great, thanks, Eric. All the studies still show that women earn less than men for doing the same work. And given that fact and the progress of the Me Too movement, legislatures, governments all across the country have been passing various pay transparency laws. DC is no exception. There are two bills currently at the DC Council, which are intended to address the compensation gap. One is the Pay Range Act of 2023, and it is an anomaly in my experience. It is a two-sentence law which requires that if an employer is going to advertise for any positions, it's got to include the max and the min salary information. And you have to make a good faith determination of what that range is before you post. The other, while slightly longer, is essentially a hand-in-glove companion to this, which lets employees see the pay scale of positions for jobs for which they are applying for. There's no indication yet what the mayor is going to do with these things, but if I were wagering, given the force of the pay transparency movement across the country, I would expect that these are going to get signed into law. Eric, to you.
Sure. The third piece of related legislation, next slide, please, is the Fair Wage Amendment Act of 2023. Went up for a public hearing this past June, along with the two pieces of legislation Ray mentioned, and will likely be up for a full vote this fiscal year. Again, these are pieces of legislation that had multiple sponsors of the council persons on the DC Council. So again, I would expect with reasonable certainty that in some form or fashion, these will likely be passed in the coming year. The Fair Wage Amendment Act, this is really a pay history ban where prohibits employers from screening or asking about an employee's prior wage history, even maximum ranges prior to a conditional offer. Again, this goes, to, making sure people are not discriminated against or suffer consequences of prior kind of pay decisions that may have been based on a prohibited basis, which kept their prior salaries at a lower level. Prohibits, importantly, this law, if passed as currently written, would also prohibit employers from reaching out to past employers about an applicant's prior compensation, again, before giving them an offer of employment, which is important to know if you are, reaching out to past employers, as many DC employers do, for references or to verify employment prior to a conditional offer, during which many times people will ask, all right, did this person work from X date to X date, and what was their last date of salary? That would be a prohibited inquiry under this law as written. Finally, there is the Minimum Wage Clarification Amendment Act. And this is a small piece of legislation which simply addresses some ambiguity in the current minimum wage law about whether DC minimum wage is to be paid just for the hours an employee works in DC or for all hours that person works for the employer. This is important for those who have employees working between DC and Maryland and or Virginia. So under the current law, if an employee, you have to pay DC minimum wage. if an employee works more, at least 50% of their time in the district. Advocates said that this current law often is hard to quantify, leads to wage theft issues. And this new law says if you work more than 2 hours in a given day, your entire day must be paid at least at the DC minimum wage, which is currently $17 an hour, rather than in Virginia, where the minimum wage is only $12, and Maryland, where it ranges between $13 and $16 an hour. So this was simply a piece of legislation which kind of clarifies some ambiguity in the current law. So with that, I know that we're at our 30-minute mark. There are a few questions. We would like to try to address them, offline, and certainly here is our contact information. If you'd like to reach out to Ray or I directly. Again, I think it was mentioned at the beginning, the CLE code for this webinar is SS, as in Seyfarth Shaw 1623. And we thank you for everyone for joining us today.